Good morning, Your Honors. Thank you for, first I'll say thank you for granting me a continuance. I was in a car accident the day before my oral argument was scheduled.
Hopefully you're okay now.
Yes, I'm on the mend, so thank you so much for rescheduling that for me. My client, Ms. Vaughn, is on her way here, so she'll probably be joining us in a few minutes. So I'll just get straight into it. The decedent in this case, Muhammad Isaifan, passed away on December 14th in 2019. 2 days later, Kimberly Vaughn, which is the mother of the minor child at that point, M.I., and Mr. Isaifan's ex-wife proceeded to his apartment to try to collect his belongings. The appellees, Mr. Husein and Mr. Kamis, were represented as the landlords for this apartment. At the initial meeting, Mr. Husein met Mrs. Vaughn at the apartment and a friend of hers and told her she had 1 hour to access the apartment and remove some personal belongings. At that time, Ms. Vaughn noticed that some major things out of the apartment were missing. Mr. Husein indicated that none of the items in the apartment belonged to the decedent. Ms. Vaughn proceeded to point out many things that belonged to him, that she knew belonged to him because she bought them for him. At that point, there was some altercation back and forth. Mr. Husein indicated that the decedent had paid his rent 3 months in advance and that there was some additional personal items that couldn't be removed, but he didn't want to do so until an executor was appointed. For whatever reason, about a week later, Ms. Vaughn proceeds to go back to the apartment. She then meets Mr. Kamis. Mr. Kamis indicates to her that some of the personal property of the decedent had been placed in his garage. There was some conversation that went back and forth at that point, and Ms. Vaughn was escorted to the garage and allowed to remove a television, and then the remaining personal items stayed in the garage. A few weeks went by. Ms. Vaughn made several attempts to try to collect the remaining personal items and was eventually told that those items had been donated by Mr. Kamis' mother. Subsequently, Ms. Vaughn then filed her complaint on February 23rd of 2021. At all times between 2021 and her trial in September 2022, Ms. Vaughn, as well as the minor child, were pro se litigants. At some point before the trial, Ms. Vaughn was instructed at a pretrial conference that there were some deficiencies in her complaint. Those 2 deficiencies were one of the defendants' names were spelled improperly, and Ms. Vaughn was instructed that she needed to become the executor of the estate to bring the claim on behalf of the decedent. Ms. Vaughn corrected both of those things prior to trial.
Was that on the record, that instruction?
I believe it is in the record in a pre-conference, like a management schedule. So it's on the record in writing.
Thank you.
And then you will also see that Ms. Vaughn filed the subsequent motions to take care of the things that were ordered in the management schedule. Following that, Ms. Vaughn had her trial in September of 2022. She proceeded pro se. She was permitted to put on her case in chief. The defendants at the time and appellees did an oral motion for directed verdict, and that was granted because the trial court indicated that Ms. Vaughn had no standing to bring her claims on behalf of the decedent's estate. Subsequently, Ms. Vaughn retained myself as an attorney, and a motion for new trial was filed and denied, and this appeal was timely filed. The assignment of error in this case is that the trial court erred when it denied Ms. Vaughn's motion for a new trial because the trial court should have determined issues of standing prior to hearing the case in chief at trial.
Counsel, what do you do with the fact that the trial court also said that the directed verdict was granted on the basis of no standing and no damages presented?
Well, I addressed that because I addressed it just minimally in the brief because the real issue that the court addressed in its brief was that there was no standing. I don't think the evidence was really considered at trial. So I didn't really take a lot of time to address that because the court spent most of its time on the standing issue and the issues of the 60B motion.
Was there ever an attempt to amend the complaint?
Yes, so Ms. Vaughn did amend the complaint to name herself as the executor of the estate, but the problem was the court found that there was no standing, that she couldn't bring it as a pro se litigant.
She had to have an attorney?
Yes. is important to note that the Supreme Court of Ohio has held that Civil Rule 60B should be construed liberally with a view of effecting a just result. 60B was the basis for the motion for relief from judgment and new trial as requested on the appellant's behalf. To successfully move for relief under 60B, the movement must demonstrate three things. First, that the motion was timely filed. There's nothing saying that it wasn't. Second, that the party had a meritorious claim if relief is granted. I took a little bit of time in the brief to talk about this because the court talked about the issue of damages. In looking at the facts adopted by the trial court, it's apparent that the appellants had a claim for conversion. It wasn't clearly laid out in the complaint. It was a pro se litigant. But the elements of conversion are property owned by a decedent or a plaintiff, a wrongful disposition of that property, and damages. The issue was brought up about damages. Ms. Vaughn did present a list of her damages. She presented an itemized list of damages, and that is in evidence on the record.
If the complaint was appropriately amended, why does the journal entry still list the individuals as the plaintiffs?
Ms. Vaughn did what she was supposed to do. I'm not sure why the court, there was a lot of things in the record that says things were done in error. I'm not sure why it was still listed that way, but she did file a motion to amend her complaint, and the court acknowledged that.
You mean it was granted and the complaint was amended
Yes,
to be the estate?
yes. So, and the whole issue of standing was that she brought the claim as the executor of the estate, and the court said she had no standing to do that. So the complaint was amended.
The actual entry says plaintiffs did not seek to amend the complaint, just substitute the estate. So there was an estate open, but they're saying that there was no amendment to make the proper party the estate. That's how I read it.
Okay, I read it as the amendment was done, or the complaint was amended because she corrected both of the issues, but then there was no standing to remain as the executor of the estate. And I believe that's what was cited in the court's decision. I hope I'm not wrong. So the main issue here is the court stated that Ms. Vaughn was not entitled to any relief under 60B 1 through 5. I cited excusable neglect and also mistake in my brief, in both the motion and in my appellate brief. Let me first address that in the court's decision in the trial court, it stated that I didn't address both of those. I did. I talked about excusable neglect, I talked about mistake. I talked about them both briefly, but I did address them both. So the court could have ruled on one, both, or neither. But getting into the weeds of the argument, Ohio courts have held that excusable neglect is difficult to define, so the term is defined in the negative. So basically, inaction of a party is not excusable neglect if a court could find that if the court finds that the party had complete disregard for the judicial system. Here, Ms. Vaughn was given instructions, fix her complaint. The complaint was deficient in that it listed herself and her minor child at that time as the plaintiffs. She needed to bring the complaint on behalf of the decedent. She did. She made attempts. I'll say she made attempts to, because now I'm not sure if to amend the complaint. And she also corrected the name of the defendant. I know that to be true, to be certain. So she did make attempts to follow the court's instructions. However, Ms. Vaughn made the error that she wasn't aware that she had to hire an attorney to have standing to bring that claim. There's nothing in the local rules that says that. It's not apparent on the court's website. We know that pro se litigants are supposed to be held to the same standard as attorneys. However, we have to consider the fact that the trial court may have played a role in this error, and I'll circle back to that after I talk about mistake really quickly. I also cited in my brief about mistake. There's not a lot of precedent of mistake in this type of circumstance, so I just went to the classic Black Law's Dictionary definition of mistake. And that's defined as an error, a misconception, a misunderstanding, or an erroneous belief. Ms. Vaughn followed the court's instructions to correct the deficiencies in her complaint. She became the executor of the decedent's estate, and she filed the documentation in order to correct the spelling of the defendant's name. She made the error of not knowing that she needed to have an attorney to bring the claim on behalf of the decedent's estate. However, the trial court played a part in that, because standing is supposed to be determined before you allow somebody to put their case in chief on. Ohio law states that standing is a preliminary inquiry that must be made before a court considers the merits of a legal claim. There were many status conferences, things that have been continued, there was mediation, there was pretrial conferences. At all times during that trial, it could have been brought up that Ms. Vaughn didn't have standing, and the proper thing would have been to dismiss the claim. But she would have had an opportunity to bring that claim back if she hired an attorney. But what happened here is Ms. Vaughn was able to put on her case in chief, and then the court never addressed standing, the defendant addressed it. The defendants brought up the fact that standing was an issue, and the court issued a directed verdict in favor of the defendants. And so now Ms. Vaughn has no opportunity to correct that deficiency because a directed verdict was issued, and so she can never bring this claim back. And so circling back to the Supreme Court's statement that we have to construe 60B in the light that makes everything most just, the only just way to correct this issue is to grant Ms. Vaughn a new trial. Thank you.
The directed verdict, though, you're alleging, I think the court does say too, that it was based on standing, and then says it didn't present damages, but the main issue is the standing.
That's correct. And she did, and Ms. Vaughn did present an itemized list of her damages in evidence, and that's in evidence on the record. So I'm not sure, the court didn't really address it in detail in terms of the damages, it just says she didn't present damages. I'm not sure what that means though. I don't know if she just never addressed it, if the court's saying that she never addressed it at all, or she didn't sufficiently address it.
The only reason I'm asking is because when I first looked at this, I was wondering why it could not be refiled, because standing obviously is not merits.
Right.
But you're saying because it was a directed verdict, that's why you're
That's
concerned that
correct.
you can't refile.
That's why I tried for a motion for new trial. So when I came on, after all of this happened, Ms. Vaughn had already tried to file an appeal, but my approach was to try to do a new trial first, because there was a directed verdict issue, and so maybe we could correct that with a new trial, but that was denied, so here we are.
Okay, understood. Thank you.
Thank you so much. Have a great day.
You too. And the court will take the matter under advisement.
Thank
And
you.
will issue a written opinion that will be sent to you and obviously the appellee as well. And then we release our cases electronically on the Supreme Court website.
Thank you so much.
Thank you so
Enjoy the
much.
rest of your day.
Bye-bye.